read you the preliminary instructions in this case. The plaintiff, Bonnie Martin, has filed suit and sued Fuel Fitness Center, Inc., the defendant, arising out of an injury that occurred on March 26, 2009. In general, plaintiff Bonnie Martin contends that on March 26, 2009, she was a business invitee of Fuel Fitness Center, Inc. at 12937 Wicker Avenue, Suite B, Cedar Lake, Lake County, Indiana. And she was injured while using a tanning booth provided by defendant Fuel Fitness Center, Inc. Plaintiff contends that her finger and hand injuries were the proximate result of defendant's negligent acts and or omissions in presenting for her use as a dangerous tanning booth, and her fingers got caught in fan blades. Bonnie Martin claims that the defendant breached its active and continuous duty to exercise ordinary care to keep its premises, equipment, in a reasonably safe condition so as not to cause injury to persons lawfully entering the premises for the defendant's commercial advantage. She further claims that defendants failed to properly inspect and maintain the equipment on the premises and failed to warn of a hazard on the premises, all of which she alleges caused her to suffer an injury. The plaintiff seeks compensatory damages for the harm caused by the defendant. Plaintiff must prove her claim by a greater weight of the evidence. Defendant, Fuel Fitness Center, Inc., agrees that plaintiff Bonnie Martin hurt some of the fingers on her left hand when she stuck them into the fan at the top of the tanning booth she was using at Fuel Fitness Center. Fuel Fitness denies that it was at fault for her doing this. Fuel Fitness contends that Bonnie Martin's own fault caused her injuries. Fuel Fitness denies that the fan covered by a metal grid of circular bars was an unreasonable danger for an adult such as Bonnie Martin, who was used to using that tanning booth. Fuel Fitness also denies that it knew of, should have discovered that Bonnie Martin would not discover or realize the danger of sticking her fingers through the metal grid and into the fan in the tanning booth ceiling, or that she would fail to protect herself against doing so. Fuel Fitness denies that it failed to use reasonable care to protect Bonnie Martin against the danger of sticking her fingers through the metal grid into the tanning booth ceiling fan. You have been selected as jurors to take and have taken an oath to do well and truly try this case. Keep an open mind. Do not make a decision about the outcome of this case until you have heard all the evidence, the arguments of counsel, and my final instructions about the law you will apply to the evidence you have heard. Your decision must be based solely on the evidence presented during this trial and my instructions on the law. Therefore, from now until the trial ends, you must not conduct research on your own as a group, use dictionaries, the internet, or any other resource to gather information about the issues in this case. Investigate and conduct the case, conduct any experiments or attempt to gain any specialized knowledge about the case, or receive assistance in deciding the case from any outside source. You must also not use laptops or cell phones in the courtroom or in the jury room while discussing the case. Consume any alcohol or drugs that could affect your ability to hear and understand the evidence. Read, watch, or listen to anything about the trial from any source whatsoever, including newspapers, radio, television, or the internet. Listen to discussions among or receive information from other persons about the case, trial, or visit or view the scene of any event involved in this case. If you happen to pass by the scene, do not stop to investigate. Finally, you must not talk to any of the parties, their lawyers, any of the witnesses, or members of the media. If anyone tries to talk to you about this case, you must tell the bailiff or me immediately. You may discuss the evidence with your fellow jurors during the trial, but only in the jury room and only when all of you are present. Even though you are permitted to have these discussions, you must not make a decision about the case until your final deliberations begin. Until you reach a verdict, do not communicate about the case or your deliberations with anyone else. In this age of instant electronic communication and research, I want to emphasize that in addition to not talking face-to-face with anyone about the case, you must not communicate with anyone or post information about the case or what you are doing in the case by any means, including telephone, text message, email, internet chat rooms, blog, social websites such as Facebook, MySpace, or Twitter. You must also not Google or otherwise search for any information about the case or the law that applies to the case or the people involved in the case, including the parties, witnesses, lawyers, or judge. During the trial, you may tell people you need to know that you are a juror, and you may give them information about when you will be required in court. But you must not talk with them or others about anything else related to the case. After your service on the jury is concluded, you are free to talk with anyone about the case or do whatever research you wish. I want you to understand why these rules are important. Our law does not permit jurors to talk about the case with anyone except fellow jurors. The law also does not permit jurors to allow anyone to talk to them about the case. The reason for this is that only jurors are authorized to render a verdict. Only you have been found to be fair, and only you have promised to be fair. No one else has been so qualified. Our law does not permit you to visit a place discussed in the testimony because you cannot be sure that the place is in the same condition as it was on the day in question. Also, even if it were in the same condition, once you go to the place to evaluate the evidence, in light of what you see there, you become a witness, not a juror. As a witness, you may now have an erroneous view of the scene that may not be subject to correction by either party. That is not fair. Finally, our law requires that you not read or listen to news accounts of the case, and that you not attempt to research any fact, law, or person related to the case. Your decision must be based solely on the testimony and other evidence presented in this courtroom. It would not be fair for you to base your decision on some reporter's view or opinion or upon information that you acquire outside the courtroom for a source that cannot be challenged or cross-examined by the parties. These rules are designed to help guarantee a fair trial, and our law accordingly provides for serious consequences if the rules are not followed. I trust that you understand and appreciate the importance of these rules, and in accord with your oath and promise, I know that you will do so. If you realize you have personal knowledge about this case, you must inform the bailiff or me immediately. Judges and jurors perform different tasks. I will instruct you on the law, both now and after the evidence has been presented. You will decide the facts in this case, then you will decide the outcome of this case by applying my instructions to these facts. Consider all of my preliminary and final all instructions together. Do not single out any individual sentence, point, or instruction and ignore others. Evidence is of the greater weight if it convinces you most strongly of its truthfulness. In other words, it is evidence that convinces you that a fact is more probably true than not true. A greater number of witnesses testifying to a fact on one side, or a greater quantity of evidence introduced on one side, does not necessarily amount to the greater weight of it. You alone are the judges of the evidence, including the credibility of witnesses. Credibility means believability. A credible witness is a witness whose testimony you believe. In considering the testimony of any witness, you may take into account his or her ability and opportunity to observe what he or she has testified about, the manner and conduct of the witness while testifying, any interest, bias, or prejudice the witness may have, any relationship the witness may have with other witnesses or interested parties, and the reasonableness of the witness's testimony considered in light of all the evidence you have heard. Assume that each evidence has testified truthfully. If you find conflicts in the evidence, reconcile those conflicts. If you can, based on the assumption that each witness has testified truthfully. Do not disregard the testimony of any witness without a reason and without careful consideration. If you find conflicting testimony that you cannot reconcile, decide what testimony you believe and what testimony you disbelieve. In deciding what or whom you believe, you should use your knowledge, experience, and common sense gained from day-to-day living. During the trial, the parties may offer exhibits as evidence. I will decide whether to admit the exhibit as evidence. When I admit an exhibit as evidence, you should carefully examine it without comment while you are in the courtroom. Rules of law strictly control the admissibility of evidence. The attorneys may ask certain questions or offer certain exhibits that I may rule are not admissible into evidence. Do not consider or speculate about the evidence that I do not admit or order stricken from the record. Treat such evidence as though you had never heard it, seen or heard it. Nothing I say or do is intended to suggest that you should believe what you should believe about the facts in this case or what your verdict should be. Each of you as jurors must determine the fact and the verdict. Judge the evidence from your memory of the testimony of the witnesses and any exhibits admitted in evidence. I will not provide a written transcript of any testimony. Therefore, listen to the evidence carefully presented. You may take notes during the trial. Paper will be provided. Do not become so involved in note-taking that you fail to listen carefully to the evidence and observe the witnesses as they testify. Your notes are not evidence in this case. They are only an aid to your memory of the evidence. Do not give your notes to your fellow jurors. Notes any greater weight than your. Do not give your notes to your fellow jurors. Notes any greater weight than your memory or impression of the actual evidence. You may only disclose your notes to your fellow jurors while you are all together in a jury room. Do not disclose your notes to anyone else. Do not take your notes outside of the courtroom or jury room. When your notes are not in your possession, no one will be allowed to read them. After your verdict, the notes will be destroyed. You may have questions that you want to ask the witness. Do not address any questions directly to the witnesses, the lawyers, or your fellow jurors, because there are rules about what questions may be asked and the answers that the witnesses are allowed to give. Instead, if you have questions, what we do is we give you a notepad, we write your questions down, we pass it in a basket, put your question in the basket, Bailiff brings them up to me, and then I go over them with the lawyers and we decide whether the questions are proper. Even if you don't have a question, put a blank piece of paper in the basket. The trial in this case is presented as follows. First, the attorneys will have an opportunity to make opening statements. These statements are not evidence. They're only previews of what the attorneys articulate the evidence will be. Following the opening statements, the attorneys begin presenting the evidence. They may call witnesses to testify under oath. The attorneys may also offer documents and other exhibits of evidence. If the evidence is completed, the attorneys will make final or closing arguments. The final arguments are not evidence, but are given to you to help you evaluate the evidence. The attorneys are also permitted to argue, characterize the evidence, and to attempt to persuade you to a particular verdict. You may accept or reject those arguments as you see fit. All right.